So I think Ken needs no introduction. He is the founder and principal of KMK Law, and our firm practices estate and trust law. And we have a big concentration in the area of disability as well. Ken has done incredible work in for families with disabilities. He was heavily involved in CECL funding, and obviously has a great resume and experience in the community. You can see all the information up on the screen. I won't read it, but I'm really fortunate to work with him. I'm just going to gloss over this. So unless Ken, you want to talk on it.
Yeah, maybe I can introduce Audrey and just good evening, everyone. And a special thanks to our great friends at FSI for inviting us once again to present. It's always a real honor for us, Audrey and myself, to be a part of this group. And thank you to all the families out there across the province tonight that are taking a couple of hours out of their busy schedules to listen to us. So we're really, really thankful for that. One of the great things about these presentations is I too get the honor of having the opportunity to present with Audrey Jun, who has been with me now for many years at KMK Law, and has also developed some significant expertise in the area of estates and trusts, but with a real focus on assisting families where there is disability and ensuring that we're providing for those unique families as well. Audrey has a pretty extensive history of presenting not only to families within the FSMI community, but both at local, provincial, and other conferences on a variety of topics. And in fact, in the next few months, she'll be presenting to members of the British Columbia Bar for continuing legal education around capacity as well to develop estate documents. So really a point that will come up a little bit later in this discussion. One of the other great things about Audrey's background is that she has some direct knowledge and experience working with NIDIS, which is a great resource, and we'll touch on that a little bit later. But Audrey served as a director with NIDIS for some time, and that really provides a lot of insight. So you can see her background is extensive, and again, really, really happy to have her co-presenting with me tonight. And in that regard, we're going to sort of tag team a little bit here as we go through the slides. And I just want to make sure everybody's aware that these slides are going to be made available to you. They may have already been distributed. If not, they will be distributed to you after this session. So there's no need to take notes on the documents. You're going to receive, these PowerPoints. There's also going to be an opportunity throughout this presentation and after the presentation to answer questions. And for Audrey and I, that's always the highlight of these sessions, because we always get great questions from family members. And so we look forward to having that feedback. Tonight's focus is going to be on personal planning tools. And I really want to build upon sort of understanding and differentiating between representation agreements and powers of attorney. And then within the Section 7, or within representation agreements, we also want to differentiate between the different types of representation agreements. And that would be the Section 7 versus the Section 9 representation agreement. what is relevant to all of these documents is the importance of capacity to develop those personal planning documents. And we're going to touch on what sort of capacity is necessary to facilitate planning documents. And then, of course, we also want to touch on, what happens where there is no capacity in place. And really, when we get to that stage, and only if it's absolutely necessary, we look at prospectively private comiteeship, which we'll touch on a little bit as well. But really, the intention here for families is what sort of steps can we take to potentially avoid the need for private comiteeship? Again, noting that this really is a last resort option. So when we're talking about personal planning tools, we're talking about vehicles that are only effective while you're alive. So we consider these to be living documents. When you die, they die with you. So they have no further usage at that point. And some of the, again, common personal planning documents, obviously the representation agreement, which, has, in the context of healthcare, the ability to delegate and appoint representatives to manage healthcare, and possibly routine financial health and legal planning. The enduring power of attorney is exclusively intended for financial and legal decisions. And it, as you'll hear soon, it has a much higher standard of capacity as a requisite to enable someone to develop one of those documents. An advance directive is another tool that's out there that sort of permits direction, very specific direction around healthcare, such as, for example, I do not wish to be kept alive by artificial means. I do not wish to have pain medications administered at any point. There may be certain religious beliefs that might be enacted in an advance directive. So it's very, very specific, and it's a direction to a healthcare provider, whereas the representation agreement and enduring power of attorney effectively allow you to appoint substitutes to either manage financial, legal, and healthcare on your behalf, or to support you with respect to those types of decisions. There are a number of other documents, and we're going to really focus tonight on the representation agreement and the enduring power of attorney. Now, for many of you, you may have attended a prior workshop that we've given around estate planning. And estate planning really is about determining how your wealth, how your estate will be distributed upon your death. And that's when we talk about wills and other estate planning vehicles. We're not going to touch on estate planning tonight. That was done in a previous session, and I anticipate if our friends at FSI permit, we may be invited back at a future point to do another session on estate planning for this group or other groups I will add that any of the prior sessions that we've done on estate planning are available on the FSI website. So you can always go back and review that whenever it's convenient. Those sessions are also on our website as well. So I talked a little bit earlier about the issue of capacity, and that capacity is really the foundation of each of the documents we're going to talk about. And each document will have differing issues of capacity or requirements for capacity that will determine sort of the course of action that may be available. But generally, you know, in British Columbia, there's this presumption that we all have capacity when we turn 19. Now, we know, of course, that that may not always be the case, and that there are a number of reasons why someone may not have capacity. And really, this is a sort of a transaction specific and really a nature and effect test that we apply at a specific point in time. We know that, you know, again, not all individuals are going to be capable under the law for specific transactions. And then others may lose that ability over time due to aging, disease, or accident. And so, you know, there are a number of tools that will enable us to plan for incapacity, end of life, or overall support needs. And, you know, I think a large focus of this session will be on, you know, considering the unique needs of a person with a disability, a family member with a disability, where there may be a need to have supportive decision making in place. And what are the tools where perhaps capacity is not clear, or perhaps it may be diminished to some extent. So I'm going to start with the enduring power of attorney, which again is predominantly a financial and legal tool. Again, it's utilized only while you're alive, not effective after death. So again, when you die, it dies. The power of attorney allows you to appoint an individual. We call that person an attorney, and they are then able, on your behalf, to make legal and financial decisions. Today, while you have capacity, or possibly only at a point where you lose capacity at a later point. The test of mental capacity to develop a document such as a power of attorney is a very high test. And you need to be able to understand the nature and consequences of developing that document. What does it mean to have an attorney? What is the role of that attorney? What is their authority? And exactly when does it come into effect? Do you understand the nature of your assets and the effects of delegating this responsibility to another individual? So this document generally would not be available to a person that has perhaps an element of diminished capacity. And generally, a power of attorney would be something that would be utilized by someone that has full requisite capacity to make decisions. So within that umbrella powers of attorneys, of course, there are many. And, we have the general power of attorney that, permits this broad power to handle the financial and legal affairs of the donor. And that document would generally end if the donor of the power became incapable. We also have banks that have their own sort of internal powers of attorneys that may limit the authority of that attorney to specific tasks within sort of that banking institution. So perhaps, managing a bank account, managing an investment. But I would say the more common power of attorney is the enduring power of attorney, which sort of incorporates those broad powers that we see in a general power of attorney, but with a clarification that power of attorney and the role of that attorney does not end if the donor becomes mentally incapable due to illness, disease, or accident. So what you then have is a document that's valid today while you have capacity, but it endures through incapacity up until the point of death. And that is the traditional enduring power of attorney.
Ken, would you like me to step in to
Sorry, yeah,
continue?
sorry, Audrey. Yes.
No worries. Thank you so much, Ken. So just continuing on talking further about the enduring power of attorney, we always emphasize, especially when clients own real estate, and especially if they jointly own real estate, that it's very, very important to have an enduring power of attorney. Almost more important, although I don't like to say that, than having a will. And the reason for that is because if, for example, two spouses jointly owned a home and one spouse became incapable, because of a car accident or whatever else happened, the other spouse would have no ability to sell that house, even though they might have to pay for care costs or because they have to move closer to a treatment facility or anything like that. So obviously that is not an ideal scenario. Um, you will want something in place like an enduring power of attorney so you can facilitate that sort of a sale if necessary, and also just management of finances generally. There are options if something like that does happen and there isn't an enduring power of attorney in place. And the most common option, if, for example, real estate needs to be sold, would be a court application to be appointed a private comite. We'll cover that more later, and we won't go into that at this point yet. So, in terms of an enduring power of attorney, who can you appoint? Most people's first choice is their spouse, because they have shared finances already, they trust each other to help each other in case something happens. They might appoint children, friends, other relatives. It really depends on the situation. If you don't have particular individuals that you um, have available who are willing to act in this role, you might also appoint a trust company, a financial institution, or another professional such as lawyer, accountant. Um, obviously, professional attorneys will charge fees. So usually they have a sort of fee agreement that you would review with them. Obviously, not paying them until they actually do step in. So they can be the primary or they could be a backup in case your spouse or child isn't available to act in the future. You may provide for a fee for your attorney and your enduring power of attorney as well, whether or not they're a professional or not. And attorneys are able to be reimbursed for reasonable out of pocket expenses incurred in their role while they're helping you as an attorney. So, Just in terms of the duties of an attorney, so obviously you can appoint someone. That doesn't mean that they have to act. So you'll want to have a conversation with them about what this role entails, what their duties will be. It's not necessarily an honor, it can be onerous. So just pulling some things out of the legislation, an attorney must act honestly, in good faith, and exercise care, diligence, and skill of a reasonably prudent person. They also have to act within the authority given under the document. So, obviously, each document is not identical, it can be customized according to your situation. And the attorney must also keep records and produce those records for inspection at the adult's request. So, the adult being you, if you're the person who created the document. And when managing those financial affairs, they obviously have to act in your best interest, taking into account your current wishes, known beliefs and values, and any direction set out in the enduring power of attorney. That said, you can customize your power of attorney to acknowledge the fact that you currently use your finances, to support your spouse and children and other dependents, and you'd like the attorney to be able to continue that lifestyle and the way that you structure your finances now. So there's lots of different things that you could do when drafting your power of attorney. So while managing those financial affairs, the attorney must, to the extent reasonable, give priority to meeting the personal and healthcare needs of the adult, foster their independence as much as possible, and also involve that person in any decision making as much as possible that affects them. So, this isn't really a situation where you just take over and you just kind of disregard the person who created the document at all. If they have some level of capacity, there should be an ongoing relationship where they consult with them and ask them, what their general wishes are. An attorney also is not able to create a will for an adult. And no one can really do that, so they can't dispose of property that they know is subject to a specific gift in that person's will, unless it's necessary, due to some type of legal reason or need some way to comply with their own duties. They must also not mix that property unless, for example, as a spouse, it was already owned in a joint tenancy relationship. That's not all, but that's some of the highlights of the duties of an attorney. Moving on to the other document that Ken touched upon before. So we had talked about enduring powers of attorney, which is documents that you or I can make to appoint somebody to help us with our finances and our legal affairs. Representation agreements, on the other hand, um, they're a little bit more complicated because there's actually two separate and distinct types of representation agreements. And I think Ken touched upon this a little bit. But just to be clear, you'll probably hear about Section 9 representation agreements and Section 7 representation agreements. So for everyone attending this webinar today, who signed up for it, probably somebody like you and me could likely make a Section 9 representation agreement. And that is a document that complements the enduring power of attorney. So while we create an enduring power of attorney to deal with our money and our legal affairs, we would create a Section 9 representation agreement to help us make decisions on healthcare and personal care matters. To make that Section 9 representation agreement, we need to be considered mentally capable of understanding the nature and effect of the documents you are making. So it's more of the traditional test. However, we do have a unique tool in British Columbia called the Section 7 Representation Agreement. So, this document actually has a different non traditional definition of capability. So, in addition to that presumption of capability, so everyone being presumed capable once they are 19 years of age in BC, you may be able to make a Section 7 representation agreement even if you're considered incapable of making a contract, managing your health care, personal care, legal matters, or routine management of financial affairs. So it kind of takes a broader view of what capability can be And when making this type of a document, things that people look at are, can this person express or communicate in some way, whether that's traditional communication by talking, or is it gestures or writing, or, some other way of expressing trust in a particular person that they'd like to appoint. So, Section 7 representation agreements not only deal with healthcare and personal care, but it can also deal with routine financial affairs and some legal services. So, routine, not including things like selling or buying real estate, but depositing checks at the bank, helping manage an RDSP. So it has some flexibility built in there, and it's a really great document so that for example, parents who have been helping their minor child manage their finances for years, assuming that their child really trusts them and also wants their parents to keep assisting them with matters, could continue that into adulthood because once your child is an adult, you don't have automatic authority to manage their affairs for them, even though some organizations may recognize that on an informal basis. Really, the Section 7 representation agreements allows you to have that legal authority to assist your child with a disability, and to continue to help them manage their healthcare affairs, their financial affairs, and so on. All right, so just some examples of things that these different representation agreements can authorize. So again, Section 9 representation agreements are the broadest personal planning document you can make to appoint a person or persons to help you manage your healthcare and personal care affairs. And again, as I mentioned, when you combine that with the enduring power of attorney, that's really the broadest range of planning you can do. In addition to the powers under the Section 7 representation agreement, you can authorize the representative in your RA9 for additional matters such as refusing care for life-saving treatment, some specialized medical procedures, and arrangements for temporary care and education of your minor children. On the other hand, for Section 7 representation agreements, some examples of things that authorities that this document can cover include paying the person's bills, opening bank accounts in their name, again, managing and setting up an RDSP for that adult, instructing the lawyer to begin or defend a legal proceeding, arranging for dentist appointments, physiotherapy appointments, decisions about medications, tests, and surgeries, and also deciding on living arrangements, so home share, hiring and supervising staff for Cecil. So there's quite a lot that can be done and accomplished with the Section 7. Now I'll just turn it over back to Ken to talk about some limitations.
Yeah, and thank you, Audrey. And just on that topic as well of where you can use that Section 7 agreement, it can also be and is acceptable in the context of Community Living BC, which may be more relevant to some of the family members here tonight. And it's a great tool to enable sort of a continuity of sort of supportive decision making around sort of that routine sort of healthcare, where someone is living, sort of environment where you're overseeing a funding arrangement and contractual relations with CLBC. Like any document, there are always limitations, and I think it's important to note some of the limitations of these documents as well. And so, with respect to the Section 9 representation agreements, it should be noted that at least at this point, it cannot be used for authorizing medical assistance in dying, which we'll touch on a little bit more. That being said, there's possibility that in the future that the legislation around MAID may be expanded to incorporate authority of representatives to help facilitate this. But at this time, the legislation does not permit that authorization. Section 9 agreements are also only intended to manage and to support decisions around healthcare. So it's not to be used for financial or legal affairs. And generally, when someone has the requisite capacity to develop a Section 9 representation agreement, they also would likely have that ability to develop an enduring power of attorney, which would then sort of manage any sort of financial and legal affairs. So for someone that has full capacity, the usual documents are a Section 9 agreement for healthcare, and then an enduring power of attorney to deal with legal and financial decisions. So if we move over to the Section 7 agreement, again, these documents are intended to assist and support through a representative for an adult in terms of routine financial, legal, and healthcare decision making. However, it will not authorize major financial decisions. So, if there was a property involved owned by the adult, the representative would not have the ability to manage, liquidate, sell, refinance property. The types of healthcare and personal care decisions are also restricted, and not to the extent of the authority that you would see in the more full-blown Section 9 agreement. So you would not be able to give or refuse consent to life-supporting care, abortion, etc. Those are not within the ambit of the legislation. So significantly more risks or restricted in terms of delegation and supportive decision making. So much like the power of attorney, and when we're dealing with an attorney, there are also duties of a representative, and I think they, for the most part, mirror each other. There's that duty to act honestly, of course, and in good faith, exercise the care, diligence, and skill of a reasonably prudent person to act within the authority of the actual representation agreement itself. There's also this sort of additional sort of duty to consult, within reason, of course, with the adult themselves to determine what are their current wishes, and then to comply with those wishes if it is reasonable to do so. And I think it's really so important to recognize that for the most part, a representation agreement is a supporting tool. It's not a substitute tool. The intention here is to assist someone that has a need for support in decision making, and to help them make decisions. And it only then converts into a substitute tool when that decision making ability of the adult has been extinguished and it's not permissible for them to make decisions. So it's a much more fluid document, and it's actually, why I think it's so powerful is that it just sort of respects, the autonomy of individuals to make decisions and to direct their wishes, but it recognizes that there's this need for an overriding sort of supportive model in place where there may be times where having that sort of support and assistance may actually make the decisions that much more powerful. So there's also this sort of duty to ensure that you're aware and you engage with the adult and understand what their values and beliefs are, and really attempt to do what is in their best interest. Like any sort of formal representative, there's always a duty to keep records and accounts regarding that authority. And so, with that responsibility comes a, significant duty to be accountable as well. And it may be that, there may be a need to report to a monitor under a Section 7 agreement, and even possibly the public guardian and trustee, if there's a belief that that authority is not being managed or fulfilled in a reasonable manner. So making representation agreements has become a lot more simplified over the years. When the legislation came out, the execution of these documents was very complex. And so fortunately, over the years, those provisions have lessened significantly, and so that it is now a much more simplified process. But some basic comments on the making of these documents. So we have obviously a requirement that the adult, the person making the agreement, the representative, and the monitor, if there's one appointed, which is usually more in a Section 7, must all sign the document. Now, the adult must sign in the presence of 2 witnesses. So there's not necessarily a need for a lawyer or a notary, unless one of the witnesses is, in fact, a lawyer or a notary, then you only require 1 witness. And there are sort of provisions in the legislation to accommodate folks that may not be able to physically sign a document, but may be able to direct others to sign on their behalf. Again, there are also restrictions on who may act as a witness. Obviously, we would not want a minor or somebody appointed already as a representative or their spouse, child, or parent to act as a witness, really to avoid any prospects of conflict of interest. We talked a little bit earlier about some of the other planning options, and I touched on, the advanced care directive a little bit already, but I wanted to just highlight that, that representation agreement really supersedes all other health planning tools, including advanced directives. And it should be noted, though, that, that within that representation agreement, there may be reference to an advanced care directive that has been developed that may supersede or may still be in effect, of course, notwithstanding the authority of that representative. Organ or body donation is always important for some folks, and I think it's important to just touch on that. It does require consent in advance for any sort of donation, and you need to have that capability. And generally, you must register those wishes with the BC Transplant Organ Donor Registry. I also touched on medical assistance in dying, and again, just noting that this legislation came into place in June of 2016, which effectively permits someone 18 years or older to request medical assistance in dying. There's a fairly stringent criteria of eligibility that must be considered. This legislation has evolved over those years and is broadened now in terms of the people that are able to request this. And I just think whenever we're talking about healthcare, it's important to sort of just be aware of MAID and its availability in British Columbia. But with that, again, that friendly reminder that that in terms of these documents, and specifically the representation agreement, there's not today an ability to incorporate MAID in terms of directing that authority to a representative. Audrey, I'll pass the handle back to you.
Thank you, Ken. So moving on to a different topic that we alluded to in the beginning of the presentation is this idea of committeeship. So committeeship is kind of what happens or what may happen if none of this planning was done in advance. So what is a committee? So a committee is a court-appointed personal or property guardian with the power to make personal, financial, and or legal decisions for an incapable adult. So essentially, somebody applies to the court or multiple people apply to the court saying this person needs to be declared incapable and I or these other people need to be appointed as a committee to help them manage their affairs. So the governing legislation in BC is the Patients Property Act, and it's been around for quite some time and it hasn't really changed very much. There is another process that you might have heard of, which is statutory guardianship. So this is where the public guardian and trustee of BC can also become a sort of committee of estate. It's not really a court process, it's more of an issuing of a certificate by a medical provider. That's something you may have heard of, but we won't go into that today. So the idea behind committeship is that it should really be only considered as a last resort measure when other options are unavailable. So there are situations where, it doesn't look like there's anything else that can be done. And that's when people consider committeship. And we'll go into that in the next few slides. So in terms of who can be a committee, in terms of the private committeship, a family member, friend, trust company can apply to the court. One of the reasons that it's not a attractive option is that it can be quite expensive. So the legal costs to obtain private committeship begin in the thousands of dollars, and it can be much higher, really depending on the complexity of the matter. So, for example, if there's multiple parties who are arguing that I'll be the better committee, no, I'll be the better committee, obviously the matter is going to be contested and then it's less straightforward. It can take more time, more lawyers involved, and therefore higher costs. Of course, where there's no one willing or able to act, that's when the PGT could apply or be appointed. So what's involved with a committeship application? So some of the components are outlined here. So part of the reason for the cost as well is that not only do you need to hire a lawyer, but as part of the application, the adult has to be assessed by two different physicians. So that one of them could be a family physician. It's generally recommended to have another person who's a specialist in some way, whether that's a neurologist or somebody who has awareness of the specific type of disability or condition that we're dealing with. So those physicians, after doing an assessment, would swear an affidavit, essentially sharing their opinion that the patient is either capable, you probably wouldn't do an affidavit to say they're capable, but rather that they're incapable of managing their person and or estate. So the fees that they charge can range anywhere from a couple $100 to upwards of $2,000, depending on, um, how exclusive they are. So there's that. There's also a separate affidavit that the applicant or applicants have to swear themselves, and in that affidavit, they essentially kind of provide evidence as to, their knowledge about the patient, how old are they? What are their current living arrangements like? What are their assets, expenses, liabilities, and why they are qualified in particular to act as their comité. For example, because they have financial expertise or they've helped the um, prospective patient manage their finances for the past 10 years anyway, in some other way. So lots of different reasons and qualifications that you can provide. You may also need to provide an outline of a care plan for the patient. So if they're currently in a care home, do you plan to keep them in their care home? Do you live out of the province? If you do, how do you intend to help that patient manage their affairs while you're out of province? And we might be in a little bit of a different landscape now because a lot of things are done remotely, and care homes actually don't let a lot of people in, and remote assistance might be the only way you can assist somebody living in a care home. But there's lots of different considerations when putting together this sort of a report. The public guardian and trustee also reviews the application and they charge a statutory fee, which is currently $525, including GST. And as well, certain individuals will be notified of the application. So, next of kin, people who are appointed as attorneys or representatives. And when notified, they also have the ability to submit competing applications if they feel that they should be appointed. This whole process, depending on, how long it takes to see the physicians, get affidavits, can take 3 to 4 months or longer, really depending on the circumstances of the case. So we went over the duties and responsibilities of an executive representative, and just touching on those of a comité. Again, the Patients Property Act has been around for a while. It doesn't give very much direction on the duties and responsibilities of a comité. However, in terms of powers, they have all the rights, privileges, and powers that the person or adult would have had if they had capacity. They obviously have to use the powers for the benefit of that person or adult or their family, having regard to, the context, how much property do they have? What are their circumstances? What are their needs and their family's needs? And similarly to those other roles, they must, to the extent reasonable, foster the independence of the person and also encourage their involvement in any decision making to the greatest extent possible. Of course, the court also has the discretion to place limits on any rights, privileges, and powers that the comite could otherwise exercise. So, for example, the most common one would be if the adult owned property, the court might say in the order, you, even though you've been appointed comite and you can do a lot of things in managing that adult's affairs, you can't sell this property until you get the written consent of the PGT or you come back to court and you get the consent of the court. Or there's this large bank account with a lot of funds. We're going to put some restrictions on this one while you can manage this other one that has some sort of day-to-day funds. So it can get pretty creative in terms of the orders that the court gives. I'll turn it back over to Ken to talk about the effect of commentateship on planning documents.
Thanks, Audrey. Yeah, so, obviously when we get to the point of having the court appoint a committee. The impact of that is that we are now terminating all powers of attorney and representation agreements previously in place, unless the court otherwise orders. And there is a provision under the representation agreement and the Patient Property Act whereby you may still be able to sustain a representation agreement, notwithstanding the appointment of a committee. But generally speaking, the intention is that that committeeship terminates all other personal planning documents in place. So, we've kind of alluded to a little bit of the sort of the pros and cons of committeeship, but I just want to run through a couple of points here just to sort of provide a little bit more clarity on committeeship. And obviously one of the benefits of committeeship is that we now have the full protection of the adult, right? And so if there are any concerns for the safety and financial security of that adult, committeeship, will preserve and prevent those concerns from becoming more progressive. It again is a last resort tool, and it is assistive for individuals that may have not been able to avail themselves of other planning tools, such as a power of attorney or a representation agreement. The other thing that we have when we appoint a committee by the court, we have now oversight as well from the public guardian and trustee. And so with that appointment comes a duty to report to the public guardian and trustee fairly regularly. And there's, again, statutory requirements and regulated requirements of a committee in terms of reporting their activity to the PGT. So there is this constant oversight when that committee is appointed beyond the date of the court application, and that will continue for the life of that order. So again, we always note that committeeship is, and in our minds, always a last resort option, and it needs to be carefully considered because there are some significant negatives, and so we want to ensure that we understand sort of the cost benefit of committeeship, and obviously foremost, when you're looking at committeeship, you are effectively saying we're going to remove the autonomy of that adult to make decisions. And courts in British Columbia don't take away that autonomy without great consideration and diligence. And so, we always want to preserve that autonomy if possible. So removing that autonomy is obviously a very significant event in that adult's life. Committeeship is expensive. Aside from the engagement of a lawyer like ourselves to facilitate that application process, there's going to be other costs, which Audrey alluded to a little bit, around the medical professionals that will play a role, will provide assessments, will be involved in swearing affidavits, declaring that person incapable of managing their financial and legal and even healthcare decision making. So in addition to the cost, it does take time as well. This is not something that happens overnight. There is a definite process, and it would not be unusual for such an application to take several months before you've received your order. Any sort of application that goes through the court system is going to then open up the doors to public viewing. And so you've now also taken away elements of privacy because those court records are also accessible to the general public. Once comiteeship is in place, it's challenging to reverse it, although not impossible. But generally, there's a presumption that once comiteeship is in place, that the individual will likely always require a committee. I mentioned earlier that one of the pros of comiteeship was PGT, or Public Guardian and Trustee oversight. Unfortunately, it's also another negative because that committee, which may be a family member, will need to work collaboratively with the PGT in the exercise of their duties in terms of oversight. And I think that, whenever you involve a government agency in the management of somebody's financial and legal affairs or healthcare decision making, I think there's a general sense that government doesn't know us as well as family and friends. And so whenever you implement an element of government oversight, I think it just adds more complexity. It also adds more cost as well. So you might have that oversight, for protection, but you also have this, these stringent requirements and engagement of the PGT around decision making. So, there may be circumstances where, we determine whether a committee is necessary. And there is a test under the Adult Guardianship Act for the appointment of the public guardian and trustee. And usually in these situations, there's a need for the adult to make decisions about their financial affairs. That adult is not capable of making those decisions, but would benefit from the assistance and protection of a statutory property guardian like the public guardian and trustee. And it's been demonstrated that the needs of that adult would not be sufficiently met by alternative means of assistance, i.e. a private committee. And obviously, the adult has not granted any power over their financial affairs to an attorney in an enduring power of attorney, or, and unfortunately this does happen, where they may have an attorney, but that attorney is not necessarily complying with their duties. So the PGT is an option, but I think there's some really specific circumstances that would need to be implemented for that to be relevant and necessary. I just want to highlight again, because one of the reasons I think Audrey and I and FSI facilitate these sessions is that there's sometimes a belief that when your son or a daughter with a disability turns 19, that you should run out and engage the services of a lawyer and immediately get comiteeship. And really the intention is to sort of say, wait a minute, do I really need to do that? Is it necessary? And what are the circumstances that would justify, the need for comiteeship? So we ask families to sort of put the brakes on and not jump to conclusions before they have the information that they need to make good decisions. Comiteeship is not necessary for managing PWD benefits, federal pensions, as I said earlier, CLBC funding, or to make healthcare decisions. There are other tools which we've alluded to earlier. So I think it's really important to ensure that we understand what the needs are, what are the circumstances of the person with a disability before we determine what is the appropriate vehicle to enable them to continue to be functioning in community when we go from, being a minor to an adult at the age of 19. Audrey, back to you.
Thanks, Ken. So we've gone over, a series of different processes and documents that you can make to assist with healthcare. We thought it would be helpful to provide a bit of a healthcare decision hierarchy, if you could call it, in BC. So obviously at the top there, while you're capable, you will be the person that the medical professional goes to say, what do you think about this? They'll seek informed consent from you. Underneath that, if you've already been determined to be incapable by a court, then it would be that comité of person who would be consulting with you if possible, and if not, they'd be speaking on your behalf to the medical professional about that healthcare decision. If that healthcare provider finds you incapable of informed consent and there's no comité of person appointed, then it goes to a representative that you've appointed in your representation agreement. And after that, it's the advance directive if it applies to that specific situation at hand. So as Ken mentioned, again, advance directive, not appointing a person, but stating your wishes in very specific circumstances. So it can be quite limited because a healthcare provider will not want to use it if they feel that it doesn't explicitly kind of follow the certain circumstance that they're looking at. After that, if none of those options are available, it would be something called a TSDM, or temporary substitute decision maker. So this is a temporary role. It's obviously not something that you choose, but it's kind of a default scheme if there's nothing else available. So it's determined in terms of order of spouse, adult child, parent, sibling, grandparent, and so on. So there are some requirements. That individual has to be an adult, has to have been in contact with you for the past 12 months, and there must be no kind of dispute in place. So they can't be suing you for money or anything like that. So this TSDM doesn't have authority for personal care decisions, and there's no real authority in emergency situations. So it's quite limited compared to the other options that we've gone over. There's also no general authority to refuse life-supporting health care. So there's many reasons why you will want to do some planning, again, to avoid the higher costs of having to get accommodation if it could be avoided by planning in advance, and also to avoid having the decision go to somebody that you didn't intend to make that decision, or who won't have the ability to make a certain type of decision that you actually want them to be able to make for you or support you in making when that time comes. So again, to avoid those scenarios, of commentateship or having to have a TSDM step in is obviously to plan as much as possible. So, if possible, there are those two documents, the combination of the Section 9 representation agreement for healthcare and personal care, and the enduring power of attorney for financial matters and legal matters. If capability is in question, whether it's because of a disability or somebody who might be far along in Alzheimer's, or there's just other reasons where somebody might not meet the traditional definition of capability, a Section 7 representation agreement might still be available. So, with that Section 7, you can legally and directly empower somebody to assist and support you in making health and financial decisions. You can also identify specific decisions that your rep can't make or can make. The benefits of that are many. You can provide the comfort of knowing that your representative must follow your known wishes and beliefs. And you can also override that statutory scheme of consent to healthcare with TSDMs. You also avoid, if possible, court, expense of going to court, and the intrusiveness of commutation. And you also have the ability to give someone else that authority to help you make decisions rather than only to make them on your behalf. So it's really that idea of supported decision making. We've also created this chart here because we do know there is a lot of terminology, a lot of different documents that we talked about. And the first column here that's supposed to represent financial affairs, the next one legal affairs, the next one healthcare, and finally personal care. And so it kind of goes through and checks, what types of affairs does each different type of document or arrangement cover. In some cases, it is a bit more limited than others. So, for example, for the advanced directive, you can put in directions for healthcare, but it's limited because it has to match that exact scenario, and a healthcare provider may not feel comfortable following that if there is a factor in your situation that didn't exactly match your direction. So, we will be sharing these slides, as Ken mentioned, in a handout form. So you don't have to worry about copying down this chart or anything like that. I did see that in the chat, I think, was it Linda or no, it was Penny who was sharing some websites as well. So she did share the PGT website, trustee.bc.ca. There is a PGT Comité handbook that goes over the private commentation process and the responsibilities of a comité really well. She also mentioned in the chat NIDIS, which is a fantastic resource. They provide lots of support around representation agreements, and they also have a lot of other sort of handouts on other personal planning tools, as well as commentatorship and statutory guardianship. And last but not least, the KMK Law website has not only written resources and blog posts about personal planning and estate planning, but it also has a link to our webinars, such as this one, as recordings of our past webinars on not only personal planning, but also estate planning, trusts, and so on that you can reference there. And it also has links to upcoming presentations that we will be giving. So those are just some resources here, and this will also be included on the handout. All right, so I don't know if there are any questions that have been building up in the chat or if Ken has any final comments.
No, I think you've done a good job there, Audrey. Penny, we would be happy to take questions.
Okay.
And I see some are starting to pop up.
Yeah, so we have one. Can the representative create a will for the disabled adult?
You want to answer that, Audrey?
Yeah, so no, you can't really authorize somebody to create a will for you, even in an enduring power of attorney. You can't really give somebody that authority. So if somebody doesn't have a will, there's something that we have in BC called intestacy, and that's kind of essentially something laid out in the legislation saying who your estate will go to if you haven't done a will. So there's a hierarchy. Not exactly, but your spouse, your children, um, parents, siblings, there's a certain hierarchy in there of people who your funds will go to if you haven't made a will. And some people may be capable of doing a will and they don't do one anyway, and their estate will go through intestacy, or somebody may not be found by a lawyer or notary to be capable of doing so, and they won't have the chance to do so, and their estate would go through intestacy as well.
Does the representation agreement have an expiry date?
Ken, did you want me
So,
to take that one?
Yeah,
Or did you-
so generally, there is flexibility in the representation agreement to obviously provide for the life of that document, but generally there are triggers when it may come to an end, and generally it's more commonly where the person has passed away, or they have made a decision to revoke, let's say, the appointment of a representative that they no longer wish to have acting in that capacity. And remember, it's a living document as well, so it will die with you, and so it will obviously come to an end at that point. I saw a question there about, what if the representative were to pass away? And obviously, the hope is that you'll have a succession plan in the representation agreement so that it will permit for changes. So if you, appoint one person, you might add or may have a co-representative so that you'll always have somebody there. Or you may have a mechanism for, successive alternates if that person either dies or, does not have a desire to continue in that role. Having a backup plan is always welcomed, and that's important where there may be a further diminishing of capacity and perhaps an inability to develop a new document at a later point. So there's still going to be that test of capacity, and so planning for future events will be beneficial.
Okay. For an RA7, do you need to have a monitor, and do you need to register the RA7? And who do you all give this RA7 to?
Audrey, do you want to take that one?
Sure. So with a RA7, sometimes a monitor can be required. So for example, if you have routine financial affairs in there, you might need a monitor in there, or there are options where even if there are financial affairs, but you have two people appointed who always have to act jointly for finances, you may not need a monitor. Sorry, I don't remember the second part of the question, I think.
Do you need to register the RA7?
Do you need to register it? So there's no requirement to register it. I will say that NIDIS does have a registry, which can be helpful, when somebody is trying to find a representation agreement and, they don't know where it is. You can upload a copy of it and it is there for reference. So it can be very helpful. It's not required by the legislation though.
Okay. Does the person have to turn 19 before you can proceed with the representation agreement?
Yes. In fact, many families, I now hear the traditional RA7 party on the date of the 19th birthday. So you have the cake and the candles, and you might have the Section 7 rep agreement signed on that day as well. So, but the key point is you must be 19.
Okay. Can the power of attorney name beneficiaries, example, for investment funds, insurance policies, etc., and to keep these items out of the estate and limit the need for a will?
Audrey, do you want to try?
Sure. So, the power of attorney is not really a document where you designate things. I mean, you can obviously make beneficiary designations with a financial institution for certain accounts. So if you have a TFSA or an RSP, you can talk to the financial institution or other organization that you have it with and designate things directly to them. Directly through them if you don't want it in a will. A power of attorney is more for appointing somebody to assist you manage your affairs now. So it's not an estate planning document, it's a personal planning document. I don't know if you wanted to add anything to that.
Yeah, I mean, I would just add that, and Audrey's absolutely bang on. The intention is that you're not, as an attorney, affecting what we call testamentary sort of disposition. You're not effectively managing a future estate plan upon the passing of that adult, because that would equate to, effectively directing how funds are distributed after death. So a designation, for example. And so that attorney's role will be limited to that financial and legal oversight, but will not expand into the actual realm of testamentary disposition. Now, there are some cases out there that are again limited in British Columbia, where attorneys may delve into sort of estate planning, i.e., not developing a will, but perhaps developing a trust, for financial management. And, it's a very complex area, and it's a fairly isolated situation that has quite a bit of rarity. In fact, there may only be a few cases out there that have even touched on it. And they're very fact specific, but the ultimate theme of even those cases is this sort of basic foundational principle of what are the duties of an attorney, and it's really not about estate planning.
Okay.
I just want
No, go ahead,
sorry,
Audrey.
Yeah, I just wanted to add, this is kind of beyond the scope of the presentation, but and I think this is really uncommon. Like, I haven't even heard of somebody who's dealt with this, but my understanding as well is in really limited cases, attorney could apply to the court to change a beneficiary designation, but they would actually need court approval for that. So it'd be quite an involved process. I don't know why somebody would want to plan to have their attorney do that. That seems kind of more of a situation where there wasn't planning done or something wasn't anticipated and the attorney has to do that. I think there's also a specific clause in there that you can give to your attorney to maintain a certain beneficiary designation. So if it had to be renewed for some reason and the attorney is just signing off saying yes to the same beneficiary that was already designated before. So there's things like that, but I don't think that's what the person was asking, but I just wanted to note that as well.
Okay. Who do you give the RA7 to for an incapable person? Example, I know one is the doctor's COBC needs one. Anybody else?
Well, I think that'll depend on the adult themselves. It is their document, and they'll determine who receives a copy. Obviously, I think there's a sense that anybody that's named as a representative should have a copy. it may be beneficial for your family physician to have a copy, but there's no magic answer. And that's really the intention of these documents, is individual autonomy to make that decision. But if we want to ensure that there's an awareness and it's not disclosed, then obviously it may not be impacted upon if there's no awareness of that.
Okay. We have a question. Brigitte, do you want to go ahead and ask your question? You can unmute yourself.
Yeah, thank you. I have a rep agreement, Section 9 rep agreement, and it was done in 2017. Originally, it was expected that the youngest sibling would be the monitor, but there's no interest or support from 2 family members. So essentially, I don't have a monitor. Who could you suggest should be a monitor if I don't have one? Because I'm on the rep agreement, as is the oldest sibling of the individual. She's the alternate. So we're lacking a monitor.
So just a note, when you have a Section 9 representation agreement, which you've articulated, there is no requirement to have a monitor.
Oh,
That
okay.
monitor is only relevant with a Section 7. Audrey, do you want to add anything more to that?
Yeah, no, it's not required. I mean, you can have one. And to answer your question as to who, it can really be anyone. Like, it doesn't have to be a particular person. They just have to be an adult, and they have to be a person who's willing to act in that role. So, I mean, some people like to have a monitor in there because they can be sort of a quote unquote neutral party that can be consulted. But if you don't have anyone, it's not a huge deal.
Okay, and if it's a Section 7, then you do need a monitor?
Right, if there's routine financial affairs,
Yeah.
unless there's 2 people appointed who have to act together at the same time to deal with financial affairs.
Oh, okay, so then I could, even if there's no monitor for that scenario, then myself and the older sibling could act together.
Right.
But
Got it.
again, you're talking about a Section 9 agreement. So your
Yeah.
agreement is Section 9, which
Yeah.
is only healthcare,
Yes,
right?
thank you for answering my question. Thank you.
No worries.
We have another question. If both the enduring power of attorney and representative have financial powers, does this ever create tension or conflict?
So if you have an enduring power of attorney, that document is limited to financial and legal decision making. And if you have, in fact, a power of attorney, then it's most likely that the representation agreement is a Section 9 healthcare document. So there's a difference of authority. The power of attorney will manage financial and legal affairs. The Section 9 agreement will manage healthcare decision making. So in theory, there should be no conflict because they each have separate areas of responsibility.
Because she went on to provide an example that the rep has authority to determine where the person lives and to pay rent and or purchase items needed for that person.
Yeah.
Can the enduring power of attorney interfere or block any of these transactions?
Yeah. So I think the question now, it sounds like it's relating to a Section 7 agreement, not a Section 9. So I guess I would have some concerns that if you have a Section 7, which only deals with routine financial, legal, and healthcare decision making, that suggests an element of diminished capacity, which generally means that you could not develop a power of attorney because you would have not met that higher threshold of capacity. And I'm summarizing here. There may be specifics associated with this circumstance that I'm not aware of. And it may be that, perhaps there was a power of attorney in place, and there may have then been a subsequent diminishing of capacity that only permitted a Section 7. But your power of attorney would definitely have broader authority over financial and legal affairs, whereas that Section 7 agreement would have that sort of routine oversight. So I guess in theory, there's the prospect that interested in Audrey's thoughts as well, that there could be circumstances, and it sounds like a great law school problem for the future, but interesting thoughts. Audrey, you want to add anything more?
Yeah, I mean, I don't have anything conclusive. I just can't imagine a scenario where that would happen. Some initial thoughts are, if somebody's made an RA7 or an enduring power of attorney that both deal with financial matters to some extent, like, did they intend to revoke one when making the other one? I just haven't run into that before, so I'd have to investigate it a little bit more.
Okay, we have one final question. Do we have time for it? It is 8 o'clock.
Sure.
Okay, so the question is, we started an RDSP several years ago and have been receiving the DTC. Our son turned 18 in December. The CRA has informed us that there's $0 available for the RDSP grant for 2022. CRA says the DTC needs to be transferred to him through a representation agreement, but he doesn't turn 19 until December. How to handle this?
Okay, let me think about this. So, initially what I'm observing here is that there's an RDSP that obviously was set up and is continuing to be in effect for an individual that is effectively still a minor. And I assume that, Farah, you're the parent, and you now are the policy holder. So you manage the RDSP, but the actual beneficiary is your son, and he obviously qualifies for the DTC. I'm not quite sure about this issue of the $0 available for the grant. That may require some further investigation. But in terms of the DTC needing to be transferred to him through a rep agreement, the DTC is not actually transferred. And for those that don't know, we're talking about the disability tax credit. So this is a federal credit that enables someone to be eligible for an RDSP. That DTC is an assessment of the person's disability. So it doesn't matter if you're a minor or if you're an adult, it stays with you. So it sounds like you're perhaps not getting clarity from CRA about this issue, and it may require some assistance from your accountant who's assisting you with your filing of your tax return. Now, what does sometimes become relevant, though, is that when a person becomes an adult and is a beneficiary of an RDSP, again, there's that presumption at the age of 19 that they have capacity. And a financial institution may sort of assist in facilitating a transfer from the policyholder parent to the now adult child who's now an adult with a disability. However, that is again dependent on whether or not there is in fact capacity for the person with a disability to now manage that RDSP. That may not be the case. And what may be important is that if the policyholder, let's say the parent, is unable to assume the duties of policyholder, or there's a need for a succession plan because capacity is in question, a rep agreement may permit, I won't say it will, I would say it may, because simply that the government legislation is fairly unclear in this area, but it should permit the ability to change policyholders vis-a-vis the representative of that representation agreement, assuming there's a Section 7 agreement in place. What I would also recommend, Farah, is I would encourage you to seek out a plan or Planned Lifetime Advocacy Network, who does and holds a series of workshops on the RDSP as well. And I believe, and you correct me if I'm wrong, I believe FSI, it's also got workshops. And I believe there may be one that recently occurred or others that may be coming up. And it may be another area to get some input from that on that topic. But sounds like a very fact-specific situation. So I hope I've been able to shed a little bit of light. Audrey, did you want to add anything more to that question?
Only in terms of there's also an organization called Disability Alliance BC, and I think they have advocates who specifically work on RDSP DTC issues, so they might be a great resource as well.
Okay.
Great. I think that's all the questions we have. We thank Audrey and Ken for your time today. For everybody else, we can direct you to the FSI website for future meetings. Please fill in the survey that's in the chat, and I will also send it to you in an email tomorrow. And we just thank everybody for their time.
Thank you, everybody.
Thank you.
Thank you.
Thank you, Penny and Linda.